In 1995, a 21-year-old student named John Leonard watched a Pepsi commercial. At the end of the ad, a military Harrier jet landed at a high school with a caption reading, 7 million Pepsi Points. Leonard did the math. At 10 cents per point, he could buy the jet for $700,000. He collected points, wrote a check for the remainder, and mailed a formal order form to Pepsi headquarters. Pepsi replied with a letter saying the jet was not actually available. Leonard hired a lawyer and filed suit in federal court. He argued the commercial was a binding unilateral contract offer. The legal question was precise. At what point does an advertisement become an enforceable contract? Leonard argued the commercial met every requirement of a valid offer under U.S. contract law. Judge Kimba Wood of the Southern District of New York heard the case. She reviewed the commercial frame by frame. The Harrier jet appeared on screen for exactly 4 seconds. The court ruled at 88 F. Sup. 2D 116 that no reasonable person could interpret a humorous television commercial as a genuine offer to sell a $23 million military aircraft. The ruling established a foundational principle. Advertisements are invitations to negotiate, not binding offers. The case is now taught in every first-year contracts course in the United States. Pepsi continued running the commercial after the lawsuit. The jet was replaced with a T-shirt. John Leonard never got his Harrier. But he changed American contract law. Was the ad a joke or a loophole?